Welcome to the fourth session in our course, The Law of Philosophical Aspects. Now, so far, the kind of philosophy that was relevant to what we've been discussing was mostly moral and political philosophy. You can see this from even just the list of the topics we've been discussing so far, right? So we've been discussing the moral duty or the moral obligation to obey the law, and we've been talking a little bit about moral and legal luck, and then we talked about judicial review, which combined questions in ethics, political philosophy, and constitutional law theory. Today is going to be somewhat different, because today the area of philosophy that we're going to be discussing is going to be epistemology. Now, the emphasis that we've so far had on moral and political philosophy is not in any way idiosyncratic. It's a very natural thing to emphasize when you're thinking about the law. The kind of philosophy that is perhaps most directly and most naturally related to thought about the law is moral and political philosophy. That's also why it's going to be the emphasis of most of the sessions going on from today. Still, epistemology is also interesting, and there are many other areas of philosophy that are interesting, and some of them are interesting vis-a-vis the law as well. So, what is epistemology? Epistemology is the philosophical subdiscipline that asks questions about knowledge, about justified belief, about evidence, things of the sort. For instance, here are some questions that we ask when we're doing epistemology. You may want to ask, for instance, what do we know? Which of our beliefs amount to knowledge? And we should at least acknowledge the possibility that the answer is going to be nothing. You know, we can call that plan B, right? Hopefully we will be able to establish at least some knowledge. Perhaps we will have to better understand what is and what is not required for knowledge in a way that will make it at least somewhat plausible that we know some of the things we're more confident in. But skepticism, the possibility that we don't know anything, is surely a matter for discussion in epistemology. You may want to ask what conditions a belief has to satisfy in order to qualify as knowledge, or perhaps somewhat more weakly, and somewhat more basically, some would say, what conditions a belief would have to satisfy in order to count as justified belief. You may want to ask questions about evidence. You may want to ask questions about what it is for something to be evidence for something else. You may want to ask about the kind of evidence we have for different kinds of beliefs. You may want to ask what evidence is needed for a belief to qualify as knowledge, or is justified, or both. And there are many other things that we could discuss. So epistemology is a very, very large subdiscipline within philosophy. It has implications almost everywhere. And it has, as we'll see today, some implications for the law. As I'm sure you understand already, epistemology doesn't need to have implications to the law in order to be interesting or worth pursuing, but these are the connections we are going to pursue. And with some topics and some philosophical dimensions of the law, the topic is best understood, or best at least introduced, via an example. So here are two examples. The first one is called, often called in the literature, the Gatecrasher case. So here's the case. Many people attend an event in a stadium. Perhaps 10,000 people attend such an event. But you can check and see how many tickets were purchased. And when you do, you find out that only about 100 tickets were purchased. So what this means is that you know that 99% of the people attending the stadium event have not purchased a ticket, and they have violated the law. They crashed the gates. Now the police catch one of these people who attend the stadium. That's all you know about her, that she attended the stadium. She's indicted, and the only evidence against her, and really the only evidence we have in this case at all, is the purely statistical one, the numbers that we've already cited. So the police or the prosecution indicts her, and the evidence they bring is 99% of those in the stadium gate crashed. She was in the stadium. Therefore, she is guilty of gate crashing. There are many possible variations on this kind of case. We're going to get to some of them later on. You may think that the case is crucially underdescribed. For instance, has the police only caught her, or have they indicted, prosecuted many others? What criteria did they use to choose between them? Again, these are topics we're going to come back to. What if the statistical evidence is only a part of what's going on, but there's also other kind of evidence available in the case? What if the numbers are different? What if only 10 people purchased tickets? What if only 5 did? What if only 1 did? Is this enough to acquit the person who is now on trial? What if no one did? that seems like another piece of statistical evidence, but a really overwhelming one, right? Now you have 100% who crash the gates. So there are many variations, and we're going to get to them. Soon. Before we do that, though, we can just ask the simple question: how do you feel about this kind of case? In particular, should she be convicted? If she is convicted, how do you feel about that conviction? Now, I put it in terms of how do you feel about it. That's no coincidence. The reason is that many people express strong discomfort with that thought. That does not seem to be the kind of evidence that suffices for a criminal conviction. We're not even happy with the idea that she was brought to trial based on merely that evidence. But on reflection, it's really unclear why. What is the problem with the evidence in the case? Why does it not suffice for a conviction? We know that the burden of proof in criminal cases is beyond a reasonable doubt. But this expression, beyond a reasonable doubt, is more often mentioned than actually explained. It's not clear what to say, what doubts amount to reasonable doubt. If we just talk in terms of probabilities, 99% confidence is very, very high. I'm sure that if you try to put a probability number on many of the other convictions, including many convictions that we don't find intuitively problematic, you will find that the percentage is much, much lower. So if you understand a reasonable doubt probabilistically, then the thing to say about the Gatecrasher case is that we do have proof beyond reasonable doubt. We have proof way, way over the line of reasonable doubt. So perhaps that's not exactly the thing to say. Well, maybe 99% is not high enough. Again, I am very skeptical of this suggestion, at least given our practice of convicting on much less than 99% confidence. But for now, okay, maybe the number is different. Maybe the number is 99.5. That's what you need for beyond a reasonable doubt. But then we should just change the numbers of the case, right? Suppose there are no, in the current version, it's not as if there are 10,000 people in the stadium, but rather 20,000 people attending. Now, but still only 100 tickets were bought. In that case, we now have 99.5% that for each person that they're guilty of gate crashing. Now are you happy? And we can play with the numbers. You can see that it can go on for a while. The discomfort with the thought that this kind of evidence may suffice for conviction is to a large extent independent of the precise numbers. It doesn't depend on the precise probabilities. So the discomfort should be diagnosed differently. It's not about probabilities. And as I already said, if you do want to put things in terms of probabilities, then compare it to how strong probabilistically the evidence is in many other cases of criminal conviction, and I'm not sure you'll be happy with the result. Here's one way of viewing it. Suppose there's an eyewitness. And suppose that the eyewitness is very, very reliable. Perhaps not infallible, but very reliable. Suppose that the eyewitness is 99% reliable. And suppose that he's testifying against the purported gatecrasher. Now are you happy with the conviction? So let me predict that you are, or anyway that you are, much less unhappy with the conviction than you were with a pure statistical evidence case. And let me also say that as far as I know, pretty much all legal systems are happy with such convictions. Eyewitnesses are, by and large, much less reliable than 99%. So if you are happy with basing convictions, at least partly, on eyewitness testimony, once again, you should have absolutely no problem with a 99% reliable piece of evidence. Once again, then the problem is not with how reliable the evidence is or how strong the statistics are, but rather with something else. What bothers us about the case is something about the kind of evidence it is, not about how strong the evidence is. So there is at the very least some unease that accompanies the use of statistical evidence, as in this case. You may think that that's true of criminal cases, but not in other cases. There's some basis for this suspicion, right? Because in criminal cases we require proof beyond reasonable doubt, and in other cases we do not. So we need another example. Here's an example that's sometimes called the red bus company example, sometimes the blue bus company example. So a bus causes harm. Now we should distinguish between two cases. In the first case, there's an eyewitness, and this is a fairly reliable eyewitness, though not marvelously reliable. Suppose that he or she is 70% reliable. And they say that the bus was red, and so it belonged to the red bus company. In such a case, the law is happy to issue a finding in torts against the red bus company based entirely on this eyewitness testimony. In this case, the eyewitness testimony seems to be strong enough evidence in order to establish a finding in tort law and indeed liability. Okay, here's the second case. There is no eyewitness testimony at all, but there is uncontested evidence that indicates the market share which is controlled by the red bus company. In particular, and I'm sure this won't come as a shock now, the red bus company controls 70% of the market share in the relevant area. So from the fact that you know that the bus caused harm, it now follows that there's a 70% chance that the bus was red, that it belonged to the red bus company. The law is not happy in such a case to establish a finding in torts or liability based on this purely statistical evidence. And I suspect, let me predict again, that neither are you. People who have thought about the law even just a little bit, and many people who even haven't, don't find the idea of establishing a finding based on this statistical evidence at all appealing. It's not just our intuitions or your intuitions and mine, but also, interestingly enough, I'm not aware of any scholar who just reports that everything is okay with using this kind of evidence. Some scholars, of course, under the pressure of theory or after argumentation, are happy to revise our practices and to desert our intuitions here. That's okay, of course, and we'll get back to that later on. But at least at the initial level, where we start the discussion, everyone agrees that there is a strong, important, weighty difference between the two kinds of cases just described. But once again, upon reflection, it's entirely unclear why there is this difference. After all, the way we describe the case, we were very careful in describing the cases to hold all other things equal. In particular, what we've been holding equal are the probabilities, the reliability of the two kinds of evidence, the eyewitness testimony in the first sort of unproblematic case, and the market share evidence in the second highly problematic case. The pieces of evidence were equally reliable. That's how we stipulated in the description of the case. Why then the difference? And notice that we are now not in beyond reasonable doubt territory. What we are now discussing is a torts case. 70% is enough, as exemplified by the eyewitness testimony version of the red bus company case. Here then is our question. What, if anything, is problematic about the use in law of statistical evidence, as in the two examples we used, the Gatecrasher case and the red bus company case? Or perhaps, once again, we should keep an open mind about this, at least early on in the discussion, perhaps the law should treat statistical evidence precisely as it treats direct, non-statistical witness, like eyewitness testimony. Perhaps that's how the law should treat it. In that case, we should go in both for a reform in our legal doctrines, but also for a revision of our at least intuitive judgments about appropriate evidence. Before we get to the discussion and to some normative arguments for and against the use of statistical evidence, before we get to that, you may want at least a characterization or maybe even a full definition of what statistical evidence is, right? You may want to say we need a definition of what distinguishes statistical from non-statistical or direct, it's something called direct evidence. And with such a definition at hand, we can then proceed to discuss the question of what, if anything, is problematic with it. So sure, it would be nice to have such a perhaps commonsensical or uncontroversial characterization of statistical evidence, but that's not going to happen. You're not going to have such a definition at all. The problem is that any way of characterizing statistical evidence will be theory-laden. What we mean by saying that it will be theory-laden is that the way to characterize statistical evidence will already depend on some of the theories that you hold. And in particular, in our case, it will depend on this theory, on the theory of what, if anything, makes statistical evidence problematic. So in this respect, although I can sort of understand the hope for a definition, that's all it is. It's a hope. It's not even a rational hope. It's kind of a wish. You may remember that earlier on in the course, I already said the definitions are not going to be helpful often. Okay, what can we do though in order to try and understand better the topic we're going to be discussing? Well, at least a good first pass at it would be to use examples. So you want to know what we're talking about when we're talking about the problematic nature, if it is problematic, of statistical evidence? Well, remember the evidence in the Gatecrasher case, the fact that 99% of those attending the stadium have not purchased a ticket. That's one paradigmatic example of statistical evidence. Remember the red bus company case, the evidence about market share? That, for instance, is a paradigmatic case of statistical evidence of our topic of discussion. Now, in the other direction, eyewitness testimony, paradigmatic example of evidence that is not statistical. Similarly, say video surveillance footage or something along these lines. So these are going to be the kinds of things we're going to be discussing. The kind of evidence that's like what we saw in the Gatecrasher case and in the red bus company market share case, but not the kind of evidence that's there when there's eyewitness testimony, video footage, and so on. Importantly, it's not as if any kind of evidence that uses probabilities is statistical in the sense that's relevant to us. It's certainly not true that any kind of evidence that is in some respect probabilistic amounts to statistical evidence in our context. Because after all evidence does that, right? So some people say all evidence is statistical, and when they do, it just shows that the way they use the word statistical is different than the way the rest of us do in this context. It's true that all evidence is probabilistic. That is, assuming that God never whispers things in your ear, such that you can be fully 100% confident in them. All you always have to go by are probabilities. That's true for eyewitness testimony, just as it is for market share evidence or for other kinds of statistical evidence. So that's true. In that sense, all evidence is statistical. It gives you probabilities rather than infallibility. That shouldn't shock you. We've known that going in, as it were. Still, within the evidence that only gives you probabilistic stuff, within that class, we want to draw the distinctions that we have already drawn, at least in the example cases. The distinction between things like market share evidence or how many people didn't buy a ticket compared to eyewitness testimony or video footage. So within the evidence that has a probabilistic feature like all evidence, we want to draw that distinction, and we won't have a definition for that. What we will have are at least the examples. As you'll see later on, after offering at least some suggestion as to how to understand statistical evidence in general and how to answer the problem about what's problematic about it, I'm going to also hint at a possible way of characterizing it. But that's how it's going to be. There is no first a definition, then a discussion of the problem with statistical evidence. The way you characterize statistical evidence is going to partly depend on your understanding of what's problematic about it. There are also complicated cases where statistical evidence of the kind that we're interested in is combined with other kinds of evidence. In fact, I'm pretty sure that all of the real-world cases are going to be of this complicated kind. But we're not going to be discussing them. So for simplicity, we're going to assume what's sometimes called in the literature the case of naked statistical evidence. So there's no evidence at all that's relevant except the statistical evidence that we're talking about. That's how I stipulated the case with a Gatecrasher case and with a red bus company example. This is going to be the kind of case we'll be discussing. Let's assume for now that there is indeed a problem with statistical evidence. So we're now not in the business of trying to argue that there is or that there isn't, but in trying to diagnose the problem that we're assuming is there. With that mission in mind, diagnosing the problem with statistical evidence, a distinction can be helpful, the following distinction. You may distinguish between two kinds of problems that statistical evidence may exemplify. One kind of problem is epistemological. Namely, you may think that in purely epistemological terms, in terms of what justifies beliefs or what evidence is needed for knowledge or something along these lines, in those terms, there is a problem with statistical evidence. You may think that statistical evidence is, in purely epistemological terms, subpar. Perhaps, for instance, you may think that beliefs based on naked statistical evidence cannot amount to knowledge. Or perhaps they cannot even amount to a justified belief, or cannot achieve some other desired epistemological status. So that's one kind of problem. You may think that the problem with statistical evidence is epistemological. But you may offer a different diagnosis. Diagnosis may be practical. Now, I should say, when philosophers use the word practical, it doesn't really mean what you mean in everyday parlance by practical, because the practical too is a part of philosophy here. So what we mean by practical, at least in this context, is the distinction with epistemic. It's not about belief, it's about action. So morality, for instance, or claims about instrumental rationality of action are practical in the sense that's relevant here. Getting back to our topic, then, you may think that the problem with statistical evidence is not or not necessarily epistemic, but rather practical in the following sense. You may think that even if statistical evidence is epistemically kosher, if there is no epistemic problem with beliefs based on statistical evidence, you may still think that there are perhaps moral reasons not to rely on such beliefs, at least in some practical contexts, for instance, in legal ones. So here's the distinction, right? There may be an epistemic problem with beliefs based on statistical evidence, or there may be a practical problem with them. In order to better understand these two options and the distinction between them, we're going to offer examples. So I'm going to offer a very quick survey of some answers that are there in the literature about what's problematic with statistical evidence. And I'm going to give one example of an epistemic answer, one example of a practical answer, and then one example that can sort of play both parts. And then I'm going to put forward something different entirely. Okay then, so here's the first possible answer to the question, what is problematic about statistical evidence? And this one comes from Judith Javith Thompson, that's her picture right there. And it relies on a causal condition necessary for knowledge. So here's the intuitive thought. For a belief of yours to amount to knowledge, it must be the case that what the belief is about plays an appropriate causal role in bringing about your believing it. Okay, so this was a mouthful, but here's an example that I hope will make it clear. Suppose that you believe that it's raining in Tel Aviv right now. Now, in the standard cases in which your belief is sort of responsibly formed and maintained, and perhaps is justified, sensitive to evidence, and perhaps even amounts to knowledge, what happens is that if we try to give a causal explanation of how you came about to believe that it's raining in Tel Aviv, at least one part in that causal explanation is going to be played by the very fact that it is raining in Tel Aviv. That part may be played directly or indirectly, right? So it may be that you are right now in Tel Aviv, outdoors, and you feel the rain and see it and so on. But it may also be indirect. Perhaps you are on the phone with your friend who is in Tel Aviv. Perhaps you're on the phone with your friend who is watching Tel Aviv on their computer monitor or whatever, right? Still, if your belief that it's raining in Tel Aviv can be fully causally explained without any role for the fact that it is in fact raining in Tel Aviv, then according to Thompson's suggestion and to the suggestion of many others, your belief does not amount to knowledge. Now, this is a very general view in epistemology. It's a view about the nature of knowledge or the conditions necessary for knowledge. But we can apply it to our cases as well, because with cases of pure naked statistical evidence, the causal condition is not met. Think about the examples again. Think about the Gatecrasher case. Suppose I'm the person whom the police have caught, and you convict me now based on purely the statistical evidence. Well, whether or not I actually did purchase a ticket, whether or not I am guilty of gatecrashing, does not play a causal role in bringing about the conviction, right? Because the only thing that does is statistical evidence, and the statistical evidence is the same evidence whether I gatecrashed or not. Similarly for the red bus company, in the eyewitness version of the case, the fact that the bus was red plays a causal role in explaining the legal finding. But in the purely statistical evidence case, it does not. So here you go. There is this distinction. And if Thompson is right that this causal condition is necessary for knowledge, what we get is an epistemic diagnosis of the problem with statistical evidence. The problem is that statistical evidence cannot establish knowledge, whereas even equally reliable non-statistical direct evidence, for instance in the eyewitness cases, that can suffice for knowledge. So this is a nice epistemic kind of diagnosis, but it suffers from problems in epistemology. And so I'm going to mention them very quickly. Causal theories of knowledge, that's like the general family of which this is one of the members. Such views in epistemology are out of fashion these days, and they have been for a few decades, and it seems to me that with good reason. For instance, they cannot be offered as a plausible candidates for the full scope of knowledge. There are many things that we seem to know, but in which the causal condition is not met. So here are some of the obvious examples. I seem to know many mathematical truths, but mathematical truths, at least supposedly, are abstract. They do not have causal powers at all. So if I know that the number 7 is prime, it's not as if the fact that the number 7 is prime plays a causal role in explaining my belief, because the fact that the number 7 is prime does not play any causal roles. So that cannot be a condition on knowledge if you accept that we do have mathematical knowledge. And similar examples may be multiplied in other cases. For instance, we seem to know, or to be able to know, universal generalizations, things like all men are mortal, but it's not at all obvious that the fact that all men are mortal plays a causal role in bringing about this belief. Perhaps it's other facts, like the fact that he's mortal and that this other guy is mortal and that this other guy died. But this is not the same thing, is it? The universal generalization, which we seem to know, does not seem to satisfy the causal condition purportedly necessary for knowledge. We seem to know all sorts of things about the future. Don't think exciting stuff about distant future. Think obvious stuff about everyday kind of future events. For instance, when I approach an intersection, I certainly believe with confidence, I'm betting my life on my beliefs about future actions of drivers coming in the other side when the light is red. So we have all these beliefs. They seem to amount to knowledge. But of course, events in the future cannot play a causal role in bringing about my belief about them, because causation works always from earlier events to future events. There is no backward causation. So there are all these purported counterexamples to a causal theory of knowledge. Now, this is not about the law. Remember, this is epistemology. But because Thompson is offering an epistemic diagnosis of the problem with statistical evidence, then all of this epistemological stuff is immediately relevant. She relies on a condition, a purported necessary condition for knowledge, but if it is not a necessary condition for knowledge, her theory with regard to statistical evidence as well just fails. So that's one kind of worry about Thompson's line. There are others. For instance, it's not obvious that knowledge is needed for justified legal findings. Perhaps in the criminal case this is so. At least in the criminal case it's somewhat plausible because of the beyond a reasonable doubt kind of burden of proof. But in other cases where the bar is much, much lower, it doesn't seem like we require knowledge. Because for knowledge, the bar is higher. It's almost like the beyond a reasonable doubt bar. So it's not clear that knowledge is relevant legally in the kind of way that Thompson seems to assume. We'll get back to variations on these themes later on. For now, though, I think that we can set aside Thompson's suggestion. Here's another kind of line. This one is moral, practical, rather than epistemic. So remember, we're still in the business of trying to diagnose what's problematic with statistical evidence. We've just gone through an epistemic way of fleshing out these details, and now we are going with a moral, practical kind of diagnosis. Now, policy is, of course, always important, and you want to promote sound policy in general, perhaps even in your court decisions. That's okay. But that's not the only thing that courts should be worried about, and perhaps it's not the main thing that courts and judges and juries should be concerned with. They should be concerned with primarily doing justice in the case. They should be primarily concerned with the rights, perhaps, of the parties in the case brought in front of them. Now, you may think that relying on statistical evidence, because it's general in this way, there's something non-personal about it. Because it's general in this way, if the courts rely on statistical evidence, what they do is go for the right policy in general. but they do it at the expense of the rights of the people specifically in front of them. So they don't do justice in the case. That's a kind of, I think, somewhat natural thought to have about it. But natural though it is, it cannot withstand criticism. Suppose you have a court that's only interested in doing justice in the case. That's the only concern that the judge, jury, whoever makes the decision has in this specific case. Still, they're going to need to rely on evidence. There is no alternative to relying on evidence, even when what you want to do is to do justice in the case. And we already know that all evidence is probabilistic. It's not as if they can afford to only rely on perfectly reliable evidence. That rule, only rely on perfectly reliable evidence, amounts to never issue any finding at all, because there is no perfectly reliable evidence. So long as the court has to issue a finding, it has to rely on evidence, and the evidence is going to be at least somewhat probabilistic. So if we're going to rely on probabilistic evidence, why not rely on the best probabilistic evidence? And the best probabilistic evidence may very well be statistical. So far, nothing has been said to show us why statistical evidence is more problematic than other kinds of evidence, not even in terms of doing justice in the case. Maybe something can be said here, but if something can be said here, that will be the answer to our question. What's problematic with statistical evidence? Not the need to do justice in the case. So we're back where we started. Here's another possible answer. This one is put often in terms of aboutness. So think about the red bus company case. When there's an eyewitness saying the bus was red, it's very natural to think that the eyewitness testimony is about the red bus company. Or similarly, if there's a video footage of me gate crashing, that evidence is about me. But the purely statistical evidence from market share in the red bus company case, or from how many people did and did not purchase tickets in the Gatecrasher's case, the purely statistical evidence, one is tempted to say, is not about me at all. It's about perhaps a wider class of people, or something along these lines. It's about a reference class. It's not about me. And you may think that I have a right that my case be decided based on evidence that's about me, that's directly about me, and not about the reference class of which I happen to be a member. Now, this kind of diagnosis of what's problematic with statistical evidence can be understood either as epistemic or practical. And I'm not going to draw that distinction now because it's unhelpful for this objection. But here's the problem, though. What do we mean by about here? It seems like the relevant about, the way in which evidence is about or fails to be about me, the only relevant about here is the one in terms of indication. Namely, something is about me if it's good evidence that I acted in some way. But if that's the sense of about that's doing work here, then statistical evidence is about me, because statistical evidence does give very good reason to believe that I did it. We can put it this way. Should you be more confident in the thought that it was the red bus or a blue bus that caused the harm? Well, given the market share, it seems like you should be more confident that it was the red bus. It's good evidence, at least in that way. It should establish differential degrees of confidence. Similarly, in the Gatecrasher case, it seems to me. So in that sense, in the evidence or indication sense of about, it seems very clear that statistical evidence is about me. It does give reason to believe that I crashed the gate or that it was my bus. So you may be annoyed a little bit by this line. No, that's not the sense of about that I am after, which is okay. It's okay as a starting point. You may want to say, no, there is a sense, not the indication sense, another sense of about, such that the eyewitness testimony is about me, but the statistical evidence is not about me. That's perfectly fair. But you owe us an account of this other sense of about. And it seems to me that in order to give an account of this other sense of about, what you really need is a full diagnosis of the problem with statistical evidence. If that's so, then the problem with the aboutness line is not that it's false, but rather that it doesn't do any work. In order to flesh it out, what you need to do is precisely what we set out to do to begin with, namely to give an account of the problem with statistical evidence. So these are some failures, I think, from the literature, some accounts that attempt to diagnose what's problematic what's problematic with statistical evidence that it seems to me fail upon reflection. But of course, there's much more to say. There are also other solutions suggested in the literature, but also you can say much more about these ones. There are attempts to save them or to save something from them, to revise them in a way that's sensitive to criticisms and offer a better version of them, and so on. We're not going to get into all of that. Instead, what I want to do now is to offer another line of thought about statistical evidence that ties it more neatly, I think, to a general line in epistemology.